Jefferson County Court at Law number 2 is in session. We have an arraignment docket scheduled for 9 a.m. on today's date of July 26th of 2022. First case is cause number 330744. Case is styled the state of Texas versus John Fitzgerald Rice, also known as John Fitzgerald Rice Sr. Mr. Rice, is that your full name?
Yes, sir.
How you doing, Mr. Rice?
Good.
That's good. Mr. Rice, you're here represented by your attorney Brian Lane. Attorney Lane, how are you doing?
Good job.
Okay. Now, attorney Tommy Coburn was here just a minute ago, the assistant district attorney. I think you spoke to him.
Yes, sir.
Is that correct?
Yes, sir.
Now, Mr. Rice has a felony case that was also set today.
Yes, sir.
And what's the status of that case?
That was reset. Another agency is looking at that felony case.
Okay.
This case, however, is not directly related to that case. If
Okay.
This court
So was
wants
that,
to offset them.
no, okay, let me, hold on a minute.
Yes, sir.
Okay, court is back on the record in cause number 330744. Case is styled the state of Texas versus John Fitzgerald Rice, also known as John Fitzgerald Rice Sr. And Mr. Rice, again, is here represented by his attorney Brian Lane. The state is represented by attorney Ray Shearer. Now, Mr. Lane, what's your announcement in Mr. Rice's case?
With Mr. Rice's case, he has a DWI. I respectfully requested another announcement. The DWI is not out of the same transaction as the felony,
Okay,
and the felony case has another agency looking at it.
Okay.
okay,
Okay.
two
And so
different,
that one's gonna,
Superseded anything here.
so if you want to, if the court would allow me another announcement, but
Okay.
it would kind of be maybe off docket with the felony. We'll just.
you just get a different date, that's what
Just
you're
a
saying?
different- Yes, yes, sir. And then that way because it's not part of the felony and I think.
Okay,
we
let me
can
ask you
resolve
this.
it.
When is the felony set? Because
When I left today, they said they'd send me a reset because
Okay.
the announcement from the attorney, from Luke, was that the other agency was looking at it.
Okay, okay.
Kind of didn't know.
okay,
Okay. Kind of, there's an indeterminate.
Yes, kind of where to put that. So
Yeah.
she didn't
Okay.
give me a setting.
Unfortunately, we can't.
Okay,
Urge along the feds to hurry things up.
Yes.
Okay.
So that's where that case is out there somewhere. So,
okay. So your case is gone. We're gonna reset your case for an announcement.
yes, sir.
And you can stand on the 4X in front of the uh, court coordinator's
Yes, sir.
chair. And once your case, you can sign for the reset. Once you sign for the reset, you give that to your client and Mr. Rice. Once you get your reset from your attorney, you'll be free to go and you have a blessed day.
Thank you, Your Honor.
Okay, so stand on the 4X.
Thank you, ma'am.
You're gonna reset his case for announcement. No, that felony, they're gonna keep it in the,
You have to. There you go, Mr. Kamara. Have a good day.
Trevante Moulton. This is two cases. We have two cases. First case is cause number 329-608. Second case is cause number 332-360. Both cases are styled the state of Texas versus Trevante Marquise Moulton or Martin? Moulton. How you doing, Mr. Moulton? That's good. Mr. Moulton, you're here. Represented by your attorney, Attorney Marvin Lewis. Mr. Lewis, how are you doing?
Good this morning. That's how you.
Now, Mr. Lewis, I see, according to the docket sheet, Mr. Moulton has two cases, and you are the attorney of record in first case, but not the second case.
I will be representing for all the cases, Judge. He had cases that came down.
Afterwards? Okay. Okay, now, he has a felony case that is also set today,
Yes, sir.
and what's the status of that?
Well, Judge, actually, they have to move those cases because the trial schedule was going on in Judge Stevens Court.
Okay.
They're not having that announcement, so I don't have that new date yet.
Okay, okay. So we could do one of two things. We could give you a different date, or we can have our court coordinator to check, and once she finds out the felony date, we can put it on the same day.
If possible, Judge, I would like to keep them on the same date.
Okay.
while we do-
Okay. You have any objections, Mr.?
No, Your Honor, no.
Sorry, sure. Okay, no objection. So let's, you can go ahead on, y'all can go ahead on and leave, because the court coordinator has to check those dates that it's been reset to. You're gonna, Mr. Moulton, you're gonna stay in contact with your attorney and your bondsman. They will be given the court dates. And, at this time, you're free to go. You have a blessed day. And Mr. Lewis, you're free to go as well. And you have a blessed day.
You do,
And
Judge.
thanks a lot, Mr. Shearer.
No problem.
And you have a blessed day as well. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to court today for what is called an arraignment. An arraignment is basically an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options is concerning your case. The case that you have in County Court at Law number 2 is a misdemeanor case. Criminal cases are divided into either a felony or a misdemeanor. Your felony cases are normally referred to as your most serious type cases. And the reason why I say they are more serious because you can get a higher range of punishment for a felony case. Your misdemeanor cases are normally referred to as your petty offenses. It does not mean they're not serious. It just means that they're not as serious as the felony offenses. And your misdemeanor offenses, as I said, the range of punishment is a lot less than your felony offense. Now, for example, if you had a felony offense, your felonies are divided into 5 categories. It could either be a capital murder, a first-degree felony, a second-degree felony, a third-degree felony, or a state jail felony. If you have a state jail felony, if you're convicted, you could be given anywhere from 6 months to 2 years in the state jail and a fine up to $10,000. If you have a third-degree felony, the range of punishment, if convicted, is 2 to 10 years and a fine up to $10,000. If you have a second-degree felony, the range of punishment is 2 to 20 years in the state penitentiary, fine up to $10,000. And if convicted of a first-degree felony, the range of punishment is 5 to 99 years to life in the state penitentiary, a fine up to $10,000. Now, the highest felony is a capital murder. With a capital murder, if convicted, the range of punishment is either life or death. Okay. Now, with your misdemeanor cases, misdemeanors are divided into 3 categories. You have a Class A misdemeanor, a Class B misdemeanor, and a Class C misdemeanor. Your Class C misdemeanors are normally those cases that are handled in the JP court or the Justice Court or the municipal court, which is the city court. With a Class C misdemeanor offense, you cannot be given jail time if convicted. You only could be given a fine. Right above the Class C misdemeanor is the Class B misdemeanor. If convicted of a Class B misdemeanor, the range of punishment is 0 days to 180 days in the county jail and or a fine from $0 to $2,000, or you could be given both such fine and confinement. If convicted of a Class A misdemeanor, which is the highest misdemeanor, the range of punishment is 0 days to 365 days, which is a year in the county jail, a fine and or a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. One of the rights that you have is on the paperwork that you have before you, and I'll go over that paperwork with you. And that is, you have a right to have an attorney. Now, regarding your right to have an attorney, you have 3 options. The first option, as you will note on the sheet that is titled Judge's Explanation of Rights to Defendants Without an Attorney, and it states, as a defendant in a criminal case, you have 3 options. Number 1, you have a right to hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. And number 3, you may represent yourself. If you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, it states, defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you will place your initials on the first line to the left. If you've already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney, which means you want to give up your right to an attorney and represent yourself, then you'll put your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will date today's date on the line that is titled date. And today's date is July 26th of 2022. Now, for those of you who will be waiving your right to an attorney and representing yourself, you will have to read and sign the next page that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 26th day of July of 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign on the line that is titled defendant, and you will place today's date on the line that is titled date. And today's date, again, is July 26th of 2022. You have other rights as well. Another right that you have is a right to have a trial by jury. When those young people are sitting in that area over there, we call that the jury box. 6 citizens from Jefferson County will be selected on your case to listen to the evidence. And after listening to all of the evidence, they will deliberate, and then they will decide whether or not you are guilty or not guilty. You also have a right to waive or give up your right to have a trial by jury. Now, if you waive or give up your right to have a trial by jury, your case will come before the judge only. And it will come before the judge in one of 3 ways. One way that it will come before the judge is by way of a trial. We call that trial with a judge only a bench trial. And the judge will decide whether or not you are guilty or not guilty after listening to all of the evidence. And the judge would also, if you are found guilty, will assess punishment. Now, if, as I stated earlier, you have a trial by jury, if the jury finds you guilty, the jury or the judge could assess punishment, depending on how you elect your punishment to be handled. The other right that you have when you waive your right to have a trial by jury, your case will come before the judge again by a plea bargain. It could be an agreed plea bargain. And what an agreed plea bargain is, it basically means that you or you and your attorney have reached an agreement with the district attorney, which is the prosecutor in the case, to settle your case. Now, once that is done, your case will come before the court, before the judge, and the judge can decide or will decide whether or not he or she will follow the plea bargain agreement. If the judge does not follow the plea bargain agreement, then you will have a right to withdraw, which means to take back your plea of either guilty or no contest. Now, if the judge follows the plea bargain agreement and you decide within 30 days that you would like to appeal your case to a higher court, that is, you would like to have a higher court to look at your case to see whether or not you've been wrongfully convicted or whether or not the court has committed an error by convicting you, then you have to get the judge's permission. If he follows the plea bargain agreement and you want to appeal, then you have to get the judge's permission to appeal. The other way that your case will come before the court is by way of an unagreed plea bargain. That means that you or you and your attorney have not been able to reach an agreement with the district attorney to settle your case. And if that is the case, you would like the judge to determine what your punishment will be. We call that an unagreed plea bargain. And then the judge will decide what your punishment will be. So to summarize what I just said, you have a right to have a trial by jury, that's one. However, you can waive your right to have a trial by jury, and if you do so, your case can come before the judge by way of a bench trial, that's a trial before a judge only, or it can come before the judge by way of an agreed plea bargain. That's agreement that you have reached with the state to settle your case, or it could come before the judge by way of an unagreed plea bargain, which means you and the state, you and the district attorney has not been able to reach an agreement on your case, and you want the judge to determine what your punishment will be. Now, you also have a right to have witnesses to come to court to testify in your case. And what witnesses do, they'll sit in that chair over there, and we call that the witness stand. Witnesses, they can testify for you or against you. If you represent yourself, you can ask them questions. If you have an attorney, your attorney can ask them questions. We call that either direct examination or cross-examination. Now, you can also waive or give up your right to have witnesses to come to court. And by doing so, you will not be calling witnesses, but it does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case, because they are the ones who filed the case and prosecuting you for this offense. You also have a right against self-incrimination. And what self-incrimination means, it's the Fifth Amendment right against self-incrimination. Maybe you've heard somebody refer to it as "I'll take the fifth." And what that means is you have a right not to testify in your own case, and the state of Texas or the district attorney cannot force you to testify against yourself in your case. Now, you can waive, which means give up your right against self-incrimination, and by doing so, you will be testifying in your case. We call that waiving your right against self-incrimination. You also have a right to have discovery. Discovery means you have a right to see the evidence that the state has against you. For example, if they have a video, they have witness statements, if they have documents, if they have instruments, whatever they have, you have a right to have access to that. We call that discovery. Now, you also have a right to waive or give up your right to have discovery as well. Now, everyone here that's here for arraignment, you are out on bond, and you're either out of jail on a personal recognizance bond, or you are out on a cash bond, or you are out on a surety bond. Surety bond, you have a bondsman, and a cash bond, you put up the full amount. A PR bond, you was released on your own recognizance. Now, everyone here also, because you've been arrested and you've been released on bond, you have credit for time that you spent in jail. For example, every day that you spent in jail, that jail time credit can be used as credit towards your punishment. So, for example, if you have served 5 days in jail, and if the state is offering you through a plea bargain agreement that you serve 5 days in jail, that means you will not have to serve any more time in jail. Why? Because you've already served 5 days in jail. And so therefore you'll be given credit for time served. If the state is offering 7 days in jail and you serve 5 days in jail, that just simply means that you will only have to do 2 days because you've already did 5 days. Now, every day that you spent in jail count as $100 per day that will go towards your fine and court costs. So, for example, if the state is offering you fine and court costs of $500, you spent 5 days in jail, that simply means you will not have to pay anything because the time that you spent in jail has already paid it off. Now, if the state is offering fine and court costs of $700, that just simply means that you would have to pay $200. Now, if you can't pay the $200, then the court can put you on what is called a payment plan, which means you can be allowed to pay off the remainder of your fine and court costs in monthly installments. You can pay it off so much a month. Now, if you cannot pay it off in monthly installments, then the court, and you're found to be indigent, then the court can convert your fine and court costs to community service. That simply means that you'll be able to work it off. Now, for every hour of community service that you do or that you work, you'll be giving you'll be receiving $12.50 that will go toward your fine and court costs. So if you work 8 hours one day, that's $100 that will go toward your fine and court costs. Jefferson County has a program that is called pretrial diversion. And that program is for first-time offenders. So if you haven't been in trouble before, this program may be for you. And the program, what will happen if you're allowed to be placed or qualified to be placed in the pretrial diversion program, the district attorney will dismiss your case. And once you complete the case, complete the program that is, it can be expunged from your record. Expunged means erased, deleted, or wiped off from your record. And in order to qualify for pretrial diversion, it has to be your first offense. It cannot be an offense involving unlawfully carrying a weapon or resisting arrest. And you have to have an attorney to assist you with the application to get into the program. If you are a veteran of one of the branches of the military, of the United States military, Jefferson County has another program that is called Veterans Court. It's for veterans only. That is also part of the pretrial diversion program. You get into the program, you complete the program, your case is dismissed, you can get it expunged from your record. The only qualifications is you just have to be a veteran of any one of the branches of the United States military. This court, County Court at Law Number 2, has a program that is called the Community Safety Initiative, commonly referred to as the CSI program. CSI program is a program that I started in March of 2017. And that program was designed to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over. And so I started this program March 2017. With that program, we have partnerships. And one of the partnerships that we have is with Spindletop Center. Spindletop is our local mental health center. Now, with that program, our partnership with Spindletop, you do not have to you do not have to be incompetent or insane to be in the program, because the program will address a myriad or several mental illnesses. For example, a person might be suffer from depression, bipolar, schizophrenia, anxiety, post-traumatic stress, ADD, ADHD, or a whole host of other mental illnesses. Spindletop Center will be there to address those issues. And what will happen is we have young people here who are in the jury box. They're from Spindletop. They will come and talk to you a little later. But what they will do, they will do a private interview. And they will do an assessment to determine what your illness may be, and they can develop a treatment plan to address whatever that mental illness is. Spindletop also has a program that is called ATAR, and the Alcohol and Drug Abuse Council has a program that is called OZAR. Those programs basically are drug and alcohol recovery or treatment programs. And what they will do is they can do a screening, and then they will do an assessment, and then treatment plans can be developed, either outpatient or inpatient treatment to address your alcohol or substance abuse problems. We also have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. And they will not only provide you training in the areas that you select, but they will also assist you at getting employment in the area that you are trained in. If you have not finished high school, you do not have your high school diploma, the CICE program has a program where you can get your GED. Now, all of these programs that I just mentioned to you do not cost you anything. They are free. Only thing you have to do is have a desire to be in the program. And once you get into the program, those programs will address either whatever needs that you have. Now, as I stated earlier, this program is designed to address recidivism, to stop people from committing crimes over and over, because the goal is to produce productive people. And the way we do that is by not arresting the problem, but by addressing the problem. We do not just give time in this court, we take our time. In this court, we are trying to, as I stated earlier, not just to arrest the problem, but we're trying to address the problem that you have. And we don't have court as usual, we have unusual court. And it's not because we're different, but because we're trying to make a difference in the lives of the individuals that comes before this court. And we're trying to make a difference in Jefferson County, in the community in which we live. We're trying to make Jefferson County a safer place for all of our children and all of us to live, work, go to school, raise our children, go to church. Now, if you're interested in the program, just let us know, and we'll be happy to give you the information that you need to get into any one of the programs to address the needs that you have. Now, at this time, we have Deputy Hinton, who is with Spindletop, and Deputy Hinton, who is he is a mental health officer. He's going to come forward and tell you I'll give you some information about the program that they have at the Spindletop Center. Deputy Hinton?
Thank you, Your Honor. Good morning. My name is Steve Hinton. I am a mental health deputy licensed by the state of Texas. I'm here with my partner, Sarah. Now, Sarah is a qualified mental health professional in Spindletop. The reason we are here today in this courtroom is because the judge cares about every single person that comes before his bench. The judge has found, more so than not, people who appear with legal issues, commonly having mental health, substance use disorders, or just lack of community resources to help you. Excuse me, the judge believes that he can help you with these underlying issues, he can get you on the type of rest. Maybe this is your first time to be here, maybe it's your 10th time to be here. Sarah and I, we actually have a system in place that we can get you plugged in to resources that best fit your particular situation. We don't know what that is, but we'd give you an opportunity to visit with you and see if there's something we can do to help you in that manner. Also have a brochure here. On the front of the brochure is, on the back of the brochure tells you a little bit about what we do, why we're here, and some advantages of taking advantage of it. Also on the front is a 1-800 number. If you ever find yourself in some place, you can call that number and get help immediately. So I'm gonna ask you to do something that may be a little bit uncomfortable. Maybe you didn't expect to do something like that, especially in a court setting. I'm gonna ask you, when the court goes into recess and Sarah visits with you, to share that need with her so that she can speak to you privately if you want to do that. If you don't want to do that, we just need to make sure we have your information. We will call you and talk to you in a place that may be more convenient for you, where you can open up whatever best suits you. We're here to advocate for you. We're here to help you. It's going to take y'all doing y'all's part as well. So does anyone have any questions? Yes, ma'am. We can talk about that and decide if maybe you're getting all the benefits and resources that are due you. Maybe some help you navigate some things, because sometimes there can be some red tape associated with it. And we just want to make sure we help you with that, okay? Anybody else? Thank you. Thank you very much. I'm going to give this out to you here just shortly. Thank you, Your Honor.
Okay, thank you, Deputy Hinton. Okay, ladies and gentlemen, the paperwork that you have that has been handed out, we have our core personnel here. If you need any assistance, they'll be happy to assist you with filling that paperwork out. Now, we're going to go into recess. Now, if anyone needs to use the restroom, the restrooms is right outside the courtroom to the right. The women is at the far end of the hall, and the men restroom is at nearest side of the hall. Now, we'll be in recess, and once we finish going over all of the paperwork, we'll call you up one at a time. So at this time, the court will be in recess.